and then assessment. Now, in this entire scheme, 130 for one and 132 operate in two different things, we understand. But then there has to be a harmonious reading of this. Because they don't operate individually, they operate different means, but there has to be a harmonious, I would say harmonious construction, but it has to be construed harmoniously. Otherwise, the investigations would become, meaningless.
Well, with due respect to Lordship, I could, this is one of the view which your Lordship is expressed. But if you read the section 141A,
Reports which I have followed, they say that the power under 131(1)(a) does not get exhausted with the invocation of 132. It remains live. It depends upon, of course, if it is absurd, if it is without merits, can be struck down. It is open to judicial scrutiny. But then you can't curtail the powers of the investigators. And senior officers have given this power. But every day it happens. I'm surprised how this is
it is
every day, every search.
Every search and everything which was going on.
And this is the logic.
With due respect to your Lordship,
You know this defense statement with due respect. We understand.
No, always, if something was going on for all throughout, and that is illegal. If I can, I will try to demonstrate also to your Lordship. I will try to convince only Lordship. If somebody department was, if the department was, I'm sorry.
Yes,
If department was doing something,
forget about it.
but I'm saying that we have to read the section. If your Lordship comes to the conclusion on the basis of the section, irrespective of what is going on and what is this, your Lordship will certainly, will interfere with the judgment.
Yes.
And if I can convince your Lordship that 132(1)(a), the notice cannot be issued after the search, this will be my only effort to demonstrate before Lordship that 133(1)(a) notice cannot be issued after the search has been completed.
Please give us training.
I think his appeal is there. I think thereafter, it appears that I am very tough now because my learned friend without argument, your Lordship.
Basically, the interpretation.
For almost that structure, we can ask just explain what I just told you. But again, you are perhaps as I have been told and as I understand, you are the tallest figure in the tax laws here.
No, my lord.
It's
Authority. I'm very small, my lord.
In fact, a person with my negligible knowledge in tax should not even venture to question you. But prima facie, this is what I.
My lord, that is the greatness of your Lordship. I am very small, my lord.
I basically, this court has expertise in criminal and other branches, public interest and service law and other things. The criminal, of course, but tax is where I would learn from you.
Well, I had a very tough time.
My brother is
I had
saying the same what.
Well, I had-
we are not able to find the judgment to be sustained.
I had a very tough time, a few days back when I filed a petition, in the excise matter, So to say, that the Lordship doesn't have that is not acceptable at all.
Still, since I have been asked to, since it is my duty, I must equip myself. But experience is very different. Therefore, it is your responsibility to figures and not let us go wrong.
Well, I will certainly only on my submissions, and if according to me, if I am not satisfied that according to me the case is not there, well, I will submit that the case is not there.
Yes.
Your Lordship may interpret. Huh? My lord, I'm not little handicapped. These people have not got the act itself.
You have not complete view of the court.
My lord, I,
Give us the judgments.
well, I'll try to. You'll also next week. You'll also fixed. Next week you'll also fix the method. And I, well, understood you.
Today perhaps were not prepared for no arguments by the appellant and the court asking you.
Well, certain things are also there. My colleagues have not received the material instructions. So
As a way of all, behalf of the respondent. Let this matter.
next week,
That,
Say,
you know,
I have got a few judgments from the Calcutta.
because
You did not from child versus some. Ramesh Chandra versus CIT. Then Dr. Pratap Singh versus Directorate of Directorate of Enforcement. Then ITO versus Said Brothers. These are some of the important cases which have been followed everywhere. And the practical experience which I got, any of the persons who I defended, their premises defended the criminal side, their premises were raided. And after 131 summons were issued.
well, my efforts will, I will go through the judgments, and my efforts will be only to place the law before Lordship.
Yes.
Whatever is there, and thereafter it will appeal also.
What day do you want?
But any next any date you lost.
Probably on that day, we will not speak from your side. You will have to tell us the judgments.
Yes, yes.
I'll give Melon one my 4-5 page note along with the judgments, so that it may become convenient to us.
As paid for the others.
26 no 5.
25.
18
Melon,
18
bye. Sufficient time is given. For the search and seizure so far was there, Melon. I already submitted for the court that this submission was not advanced before Lordship. The only single judge. My lord.
And I did not tell the advocates, especially senior advocates like you, and whatever we say, it's absolutely true. They are open till the last.
My lord,
Absolutely tentative.
well, it will,
Communicate it so that he may respond.
my lord, it becomes also easier for us also to go through the judgments which are there and take the view, my lord. Really am grateful to your Lordship express the view, otherwise I will not come to know, my lord. I am obliged. My lord.
Item 4.
Yes, my lord.
Lord, as far as the facts are concerned, we can start from the judgment of the learned single judge, my lord, pursuant to which the impugn order was passed. Now that
Because there are judgments which you have shown to us,
yes,
which just speaks to the complaint. And there should not be, there should be no distinction between items or.
there is only one judgment. PA Bhatt. The rest are all, my lord, taking a contrary view. Yes, yes. Only-
Just all judgments made before,
Ah.
they specify.
Yeah.
Justice Rizkesh Roy,
Ah.
others.
Yes. Honorable Justice Nageshwara, all. No, my lord, now the question is, they were implementing a direction issued by learned single judge. And that order has attained finality. There is no appeal against that order. Now, while deciding a matter, whether a particular judgment has been followed or not by the administrative authority, where was the scope to travel to my lord P.A. Bhatt? No, my lord. Because Supreme Court says,
And then-
yes,
Now we are looking at it from a different.
yes, yes.
Jurisdiction.
My lord, there are,
Government says it.
yes, yes, yes,
From a different aspect.
yes.
Now. For the moment, I suppose your objection is that the moment you are, I mean, all the improvements which have been given to others are not given.
What they have done, they have mechanically applied the, my lord,
This one is
Ah.
behind that
Veil.
facade,
Ah.
behind that veil,
ah,
that you are getting the same starting salary.
Ah.
that you gave.
yes, that's the point.
That's calculate of the last.
Yes, precisely, that's the point.
To that extent, we would not blame them 50,000 basic, they have started with you, but you are not getting increments.
Yes.
Therefore, your counterparts in the.
Allopathy, they are getting much higher. The example which I have given.
Consider this.
Yes. Well, that instruction I have got, my lord. In fact, the order that was impugned in the writ petition, that speaking order speaks in, my lord, in this regard, that, my lord, the increments were granted. Lordship will see 168, which was under challenge before the learned single judge. In my instruction also, we have stated that it has been given. My lord, yeah, what the written instruction.
এইখিনি গোটেই অসমীয়া বেলেগ বেলেগ নহয়? কিন্তু চিঠিখনৰ কথা কৈছা?
Yes, so far as my, probably, my lord, this particular, my lord, in the second para regarding the revision in 2024, why that benefit has not been granted is, my lord, the PA Bhatt's case. Yeah, at that point of time, the PA Bhatt's case came into being, my lord.
On pay parity, PA Bhatt is not on pay parity. Let us be very clear about it. All the other judgments are on pay parity.
But it is of
Latest case.
latest, my lord, it is of 2023. That is the latest judgment. That particular judgment, my lord, categorically deals with this particular issue. My lord, Justice H. Roy's order is regarding, my lord, the age of retirement, my lord, 65 or 60. That's a. Yes, but, my lord, PA Bhatt is exactly on pay parity between allopathic doctors and Ayurvedic doctors. And that went to the Honorable Supreme Court. There it has been held that they are not entitled. My lord, while. Yes, my lord. Lordship will see page 234 of the writ appeal, my lord, appeal memo. My lord. Lordship will see 239, my lord, the issues framed, it is at para 24. Para 24, page 239 of the appeal memo, otherwise, my lord, SCC. Twenty-four, my lord, two issues, whether different scales of pay can be fixed for officers appointed to the same cadre on the basis of educational qualification possessed by them. Two, whether allopathic doctors and doctors of indigenous medicine can be said to be performing equal work so as to be entitled to equal pay. Para 37, my lord. My lord.
To consider. Last, and my lord, that New Delhi case was not even considered. Not only New Delhi, that Uttarakhand case and my lord, judgment from Telangana High Court. Both were not considered. And my lord, issue number one was totally, as I don't know relation with this, that was a issue, my lord, whether based on higher qualification, there could be differentiation. That issue we are least concerned in this case, my lord. Regarding the second issue, my lord, none of the three judgments which were already holding the field were taken note of. In fact, the other two judgments were on pay parity. Uttarakhand judgment, which has been upheld by the Supreme Court, and Telangana judgment, which has been upheld by the Supreme Court. And most importantly, my lord, no, my lord, I have another point. Now, my lord, until and unless the order of the learned single judge is interfered with, how can they tinker with this order of judgment, my lord? That order has attained finality. Even if, my lord, even in view of, my lord, PAVR, they cannot ignore the judgment of the learned single judge, pursuant to which they passed the impugned order, which was challenged before the learned single judge. Lord, can I place one judgment on that point, my lord?
My lord,
After you pays them at 20,000.
lordship.
Now, this first, if we have back for there, perhaps we would not have been required to do this. But now that you have done, because you are also promoting as a state Ayush and other. And that's one of your endeavors as a part of national policy. We have great pride in our legal history. That's what Justice Sam Subramanian writes, rightly so. But then they can't perform post-mortem duties. They can't. Emergency duties, surgeries, PMS, they do some kind of surgeries, superficial skill, epidermal. Of course, the quality of education, the level of education, the time spent in the MBBS, outdated MBBS degree in PMS are falls apart, very different.
Lordship.
First, the Ayurvedic medicines do wonders, certainly ailments. But then there is no check how much of any metal has been used, what has been used. There are so many things. It's not always advisable to buy it off shelf and going by the advertisement, consume it.
Right.
Because cost, I mean, it has taken the life of
Many people.
one of my colleagues,
Yes, sir.
judge, sitting judge of Department of Court. He was very fond of Ayurvedic medicines.
Right.
And his liver failed. What is that called? SGFR, the filtration rate.
SGOT, SGPT.
No, SGFR, the filtration rate,
Oh,
it was lessened and it could not be
recover.
resuscitated. He died at Madras. While sir was appointed after. A man known for his dietary habits, all vegetarian, without bad lesson and everything, but every day he used to have this leaf for to all kinds of.
Lordship.
And then our doctors, the High Court doctors, keep advising us that please don't even eat chavatas. Because it's not regulated.
Right.
Nonetheless, that's besides the point. Now, after you have put them on 50,
My lord.
now by what? Whether you discriminate them on grounds of increments.
No, my lord. Lordship
You
will.
say that it's a fixed rate, you won't implement.
No, increment given. Lordship will see 168 for a moment, my lord. The speaking order which was passed pursuant to the learned single judge's order. First date petition. After the pay parity order. 168.
68.
Yes, my lord. Lordship will see pursuant to that order exactly from the specific date prescribed in the court's order. It has been given from 18/12/2018.
Whichever is higher.
No, I have after you.
Whichever is higher. Disparity to connect.
Yes, my lord.
No, my lord, whichever is higher.
Because of the increment, my lord.
No, the early influence.
Yes, the third para.
The yearly increment released during the corresponding period by orders issued from time to time shall also be taken into consideration with the revised initial remuneration or remuneration drawn, whichever is higher. That because they will only take note of the increment which have been earned just to find out whether that ceiling has been reached or not. Thereafter, nothing will be paid. What has happened, my lord? Now juniors are getting more and the seniors are getting less. My lord, let them give an example how they have worked out. Let them give an example, my lord. Let them file an affidavit saying that they have implemented the judgment in letter and spirit. Let them give 5 examples of Ayurvedic doctor and 5 allopathic doctor.
You put it in record, I think this,
Lordship.
this instruction will satisfy you.
Lordship.
Yes.
Please give a copy.
No, I have given him a copy.
You come to the last line.
Subsequently,
No. Based on the present initial remuneration of 50,000 per month.
1 second, my lord. Yes, based on the present 5,000 per month and applicable, any grievance arising shall be examined and disposed of separately on a case-to-case basis. No, my lord, let them give 2 examples, my lord. That will satisfy. Let them show that they have implemented the order and yet we are not
In
prejudiced.
fact, my lord,
Now, suppose he is drawing a salary of 50,000.
Ah.
How will he cheer?
my lord.
How will it be added? Whether there will be any ceiling,
Ah.
whether there will be any discrimination with respect to IU.
My lord, I understand.
No, my lord. According to the learned single judge mandate, my lord, with effect from that 18, it has to be equal. Let them show how it is equal.
But then, say, there will be a bias.
Very categorical.
No, my lord. No, my lord. My submission would be slightly different, my lord. My submission would be
But
to determine this case.
not offending you. That's what.
No, my lord.
Yeah.
With all respect, I am submitting, my lord. PA judgment cannot come into picture in this case because the judgment of the learned single judge has attained finality and learned single judge's order is with effect from a particular date, there has to be parity.
Nobody is questioning that.
Yes. Now
Nobody is
let them
questioning.
show that they have resorted to that parity exercise reasonably. Let them show that. By giving one example of the same date.
Nobody is saying that person to PA. Let them take away 35,000.
No, that we are not doing that. Yes.
Millard,
So therefore, don't say.
Millard,
Distinction is there.
Millard, I will not comment on the PA judgment, Millard. People who were present during the course of the hearing, some personal experience were quoted, Millard, by this learned judge, Millard. End of the day, there were 3 judgments of the Supreme Court on the subject. Okay, no. No, I will not disclose what transpired, but I am just indicating.
Transpire.
Yes.
So therefore, what we have read is clear distinction and way. So far as the pay parity is concerned. Now you are not concerned with that. Presently, 50,000 is the starting salary for MBPS.
Then plus increment.
Plus increment. How they will work out the.
No, my lord. With effect from the date indicated by the learned single judge, or from which date parity has been ordered, at least I must get same pay as a medical doctor. That's all. If they can show it very well. Oh.
My lord.
Uh-huh.
So then we have decided, but my lord, one thing I would like to point out in my instruction, from 2024, there is a disparity. After the PA birth, the revision was not granted to the Ayurvedic doctors. I must point it out, my lord, because I have already placed the.
Then that judgment has
debated.
attained finality.
But one thing, my lord, I would like to point out again, my lord, that 2024, whatever development has cropped up, that is subsequent to the order passed by the learned single judge, and that has not been put to challenge before the learned single bench. That is not a subject matter of this honorable court. It's a subsequent development. No, on technical point, my lord, I am pointing.
No, it's not a question of technical point. If the judgment goes, everything goes.
I will file my affidavit, ma'am.
Which shall be required.
My only submission is let them give 1 or 2 examples.
Yes,
Yes.
how it includes only basic salary is the bundle of rights now.
Yes.
We notify on. First of all,
I love that. Keep it.
Item 46.
My lord, this matter I need some, yesterday I was engaged, my lord. I need some time.
that's
P,
100%
option.
100% option of that.
As such, my lord, the industry is passing to a very bad phase. My lord, I was just wondering, my lord,
This is 24 and this is 24 calendar year. What is now?
yes,
What is the?
if I have to take all the instruction, my lord.
That has
Lots
been
of-
extended subsequently. I will also get the data, what is the,
Oh, only thing I was wondering, my lord, once, my lord, everything has been opened up.
Such infrastructure to allow these growers to keep it in the warehouse. And.
Yes. And my lord, and the worst part is, supposing in a particular auction, if the tea is not sold, then the next time will come after 3 weeks.
Tax. It shows that there was no fluctuation in the price. Even with this. What do
Anyway,
we-
even the prices were, I'll come up with all the information.
Number one. Number two, we understand, the logic is simple. They have been fluctuating it and they have been changing it quite often. Starting with 25, 75, reduced to 55, then again for 2 years there was no cap, then again they restricted to 75. As far as I remember.
Correct, correct, my lord.
So there are arguments, but so far as the decision of the P board is concerned, with the amendment. Question, of course, if it defies logic, if it defies sense, we will strike it down. We'll ask them to review. But they would, Chaudhary says, and that is thereafter, they say that it has caused no fluctuations of our prices.
I've seen that. I've
our
heard that.
stand is we are getting better prices.
There's transit loss among them.
That,
My lord, there are many, my lord, infirmities in the process.
Sampling, every time fresh sampling is.
Yes.
Who bears it? The cost is borne by the P boards.
Yeah.
And as it is, it's passing through a bad phase.
And my lord, warehousing, as such, you are passing through a very, very bad phase.
These are areas of the not still summer.
And the extent of regulation which has been taken over, my lord, in jute industry, coffee, and all these sectors, there is no regulation. Tea only they are doing, my lord. Absolute, absolute. And whether in the present scenario, my lord, it is required, that is also.
States, including Bihar.
Lordship, I did not get.
Why only 11 states?
It's only for the northern part, Lordship. Because, no, the logic given by the authority is the dusty production in the northern part of India is less than south. Once this is channelized, maybe the south will also be taken into the
When
fold.
you want to
My lord, sometimes in July, my lord. June perhaps it can be.
wait for on behalf of the petitioner, and I agree to my response in my presentation will be.
Yes.